On behalf of the Clearinghouse on Women's Issues, or CWI board and members, I welcome you to our February meeting. I am Alana Taylor, CWI Vice President for Diversity. We're delighted you joined us today to discuss this important topic of attacks on diversity, equity, and inclusion, or DEI, efforts to maintain and fight back. As background and for context, on June 12, 2024, 22 members of Congress led by then Ohio Senator J.D. Vance and Donald Trump's vice presidential candidate in the 2024 election introduced the Dismantle DEI Act of 2024. With respect to the act, Senator Vance stated, the DEI agenda is a destructive ideology that breeds hatred and racial division. It has no place in our federal government or anywhere else in our society. The proposed legislation sought to eliminate all federal DEI programs and funding for federal agencies, contractors which receive federal funding, organizations which receive federal grants, and educational accreditation agencies. Later in the days immediately following the inauguration of President Trump, he immediately issued executive orders banning all DEI programs in federal agencies and contracts and outlined plans to encourage the public sector to end illegal DEI discrimination and preferences as the administration defined them. Sadly, the executive orders resulted in many federal employees involved with DEI being placed on paid leave and told they would eventually be laid off. Following week, President Trump dismissed key personnel at the Equal Opportunity Commission and the National Labor Relations Board, the independent agencies charged with enforcing workers' civil rights and protecting them from workplace abuses. The Trump administration has even encouraged the elimination of DEI efforts in organizations outside of federal control. The dismantling of DEI programs has been felt on education and on the private sector. These federally mandated DEI eliminations even apply to organizational recipients of federal assistance and actions by federal contractors. The Trump administration is eliminating long-standing DEI activities. Some anti-DEI policies arise from court rulings, including recent decisions overturning affirmative action in higher education. Many are rightly concerned about what the recent DEI changes mean for women, racial and religious minorities, people with disabilities, and transgender and non-binary people, while others are applauding the changes, arguing that DEI amounts to discrimination against straight, cisgender Christian men. A divide has formed between private businesses that are dismantling their internal DEI programs to avoid catching the administration's eye or to appease their shareholders, customer base, and others that are standing firm on their commitment to equality inclusion for all. Despite the backlash against DEI programs and initiatives, many education institutions, companies, and states are finding ways to support DEI. Today, our Clearinghouse on Women's Issues meeting will address the dismantling of DEI programs and ways to achieve equal opportunity even under these adverse circumstances. We are excited to have three dynamic speakers with experience and solutions to these challenges. Following their presentations, we will have a question and answer session. We request that you place your questions in the chat box. Now, to cover the issues that we're talking about from the various sectors of DEI attacks, we have for education, Ms. Jeanette Lim Esbrook, Esquire, CWI's Vice President for Legal Affairs. Ms. Esbrook retired from the Office for Civil Rights, where she was the acting assistant secretary during 2 administrations and director of program legal. She was the deputy assistant secretary overseeing K-12 funding to approve education for at-risk students, and at DOJ served as the education section litigation staff. For the federal government, we have Ms. Jocelyn Samuels, Esquire, former Trump and Biden appointed commissioner and vice chair, U.S. Equal Employment Opportunity Commission. Ms. Samuels also previously served as the former acting assistant attorney general, Civil Rights Division, Department of Justice, former director, U.S. Department of Health and Human Services, Office for Civil Rights, and as vice president, National Women's Center. Last month, Ms. Samuels was illegally fired by President Trump from the EEOC. Despite that, she has remained committed to advocating for lawful and effective DEI initiatives. Last but not least, to address the private sector, we have Ms. Janice Mathis, Esquire, current general counsel and the former executive director for the National Council of Negro Women. Ms. Mathis also served as the former general counsel for vice president of Reverend Jesse Jackson's Rainbow Push Coalition and the Citizenship Education Fund. Ms. Mathis held the position of Deputy Issues Director to Michael S. Dukakis and served as Georgia's Special Assistant Attorney General for 18 years. She serves on the board of the National League of Women Voters, Delta Sigma Theta Social Action Committee, United Way of Northeast Georgia, the Area Community Foundation, and currently the Mary McLeod Bethune Council House National Historic Site Commission. Please join me in welcoming these great speakers. Ms. Esbrook, I turn it over to you.
Thank you, Alada, and good afternoon, everyone. I will be discussing diversity, equity, and inclusion in the context of education, both K-12, K through 12, and post-secondary education. Let me first apologize to you that I'm going to read from my presentation. There's so much to say, and I'm afraid if I don't read all that I have researched and presented, I'll miss something. I'll answer your questions, as Alada said, at the end of our 3 presentations. Let me first start off by talking about the end of affirmative action. The United States Supreme Court, at the very end of their 2022 term in June of 2023, ended 50 years of affirmative action admission policies at colleges and universities. In Students for Fair Admission versus President and Fellows of Harvard and the University of North Carolina, the court determined that the admission practices of Harvard College and the University of North Carolina violated Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. To me, and to all of us, this was a harbinger of more to come. It was like a weather report, a prediction that programs furthering diversity, equity, and inclusion, DEI, were in for stormy weather. And we have seen actions targeting DEI programs. It came in like a 5-level hurricane. SCOTUS's anti-DEI decision that ended affirmative action declared that higher education institutions can no longer be concerned with remediating discrimination or extending an opportunity for a college degree to those who previously were unable to acquire one, or provide a more diverse learning environment with the use of affirmative action. The majority opinion was written by Chief Justice Roberts and joined by Justices Thomas, Alito, Gorsuch, Kavanaugh, and Coney Barrett. Dissenting opinions were written by Justice Sotomayor and Jackson. Justice Elena Kagan recused herself as she had represented the United States as President Obama's Solicitor General in the oral argument of these cases. During the Senate confirmation hearings, Gorsuch, Kavanaugh, and Coney Barrett all promised and stated they believed in and provided their allegiance to stare decisis. They believed in and provided adherence to case precedents. For affirmative action, this was the leading case was the 1978 case of the University of California versus Bakke. For many, if not all of the recent confirmation hearings, we have seen this practice of nominees taking one position during Senate confirmation and then acting just with the opposite policy position once they are confirmed. With respect to affirmative action, excuse me, let me get some water. With respect to affirmative action, there was a legal recognition that these efforts had added to student diversity in university classrooms, resulting in robust exchanges of ideas and conversations, leading to more informed class content. Possessing a more diverse understanding from this more diverse education, graduating students were better informed, educated, and prepared to succeed in an increasingly diverse population of the United States and of the world. That was one of the deciding factors supporting affirmative action prior to 2023. Ironically, the majority opinion relied on the seminal desegregation case, Brown v. Board of Education, to support their decision. The Supreme Court found that white and Asian students were discriminated against by these two universities' affirmative action policies, and therefore in violation of Title VI and equal protection. On the other hand, Black and Hispanic students have historically been underrepresented, especially at selective colleges such as Harvard and UNC. Since 1978, with permissible and limited use of affirmative action, the number of Black and Hispanic college students gradually increased. After the Supreme Court ended race consciousness college admissions in 2023, the New York Times, in an article, asked, "What is the effect of this decision on college freshman classes in 2024? Relying on data from the National Center for Education Statistics for 59 selective colleges, the New York Times article attempted to answer the question they had posed. Cautioning that it was still too early to draw definitive conclusions, the article reported that on average, not unexpected, average Black and Hispanic enrollment declined. The Black freshman population at the 59 selected colleges dropped from 7% to 6%. The share of incoming Hispanic students at these colleges also fell about 1%, from 14% to 13%. While it does not sound like much, a 1% drop in 1 year is significant. And it was the largest annual drop in the average share of Black or Hispanic students across these 59 selective colleges since the year 2010. The surprise was the data analysis did not show any comparable increase in Asian and white student freshman enrollment at these 59 selective colleges. This was in part due to the changing racial and ethnic demographics of the whole United States population, including college-age students. And there was a significant increase, interestingly, in the number of students who chose not to indicate their racial or ethnic identity. Even before the Supreme Court's 2023 ban on affirmative action, 8 states had already banned affirmative action. These were California, Arizona, Idaho, Nebraska, Oklahoma, Michigan, Florida, and New Hampshire. In a 2020 education policy brief, the Civil Rights Project, data analysis showed the graduation gap average at the top dozen public universities in the 8 states that had statutorily banned affirmative action was 10%. Compare this to the average gap at the top dozen public universities in states that had permissible use of affirmative action, which was 6%. Affirmative action was being effective. Now, however, we must address what may be done to maintain and push back in spite of the anti-DEI activity. Even the Supreme Court has relaxed their intense review of affirmative action DEI efforts. Recently, a coalition group sued 3 Boston exam schools, these are high schools, for their admissions practices in the case Boston Parent Coalition for Academic Excellence versus School Committee for the City of Boston. The coalition group alleged that the Boston exam schools' use of zip codes to aid in admission sections was illegal. The number of students admitted from a given zip code was determined by the percentage of eligible age students from that zip code, according to Boston Select Schools. The district court found in favor of the Boston schools because they said the coalition failed to show any illegal or discriminatory disparate impact on the basis of race or national origin. Eligible students of all races were admitted using their academic record and their particular zip code. The appellate court agreed with the district court. Then the coalition appealed to the Supreme Court, citing their recent affirmative action cases, and the Supreme Court, surprisingly, let stand the appellate and district court's opinions, finding that there was no equal protection violation, agreeing that this was not an impermissible use of race. Thus, they did not extend their ban on higher education affirmative action to the highly selective Boston exam schools. After 2023, colleges are therefore limited in what they may do to provide access to marginalized students. One still viable practice is used by the University of Texas, relying on the state's top 10% policy. This policy provided that the top 10% of students graduating from any and every Texas high school would be provided admission to the University of Texas. U of T, however, currently has changed this and modified it by using now a top 6% plan. They're being more selective. This policy recognizes differences in resources for students who come from family and high school programs in lower socioeconomic status neighborhoods. Any student graduating from high school in the top 6% has made a significant achievement, and 2 U of T indicated potential to successfully study at their state flagship university. No racial or ethnic identification was used. In addition to this approach to offer more admissions, colleges and universities have established programs that identify and provide support to encourage high school students who demonstrate potential to succeed in college. Many of these smart high school students have not considered attending college based on their lack of family economic resources and on family expectations. These students are often unaware that they are even eligible for student aid scholarships. These college outreach programs are not limited by race or national origin and have shown some degree of success. The recent actions of this new administration have identified anti-DEI requirements for government programs, resulting in eliminating many government programs and activities, as Alada laid out in her introduction. The effects specifically on the education department and on the work of the Office for Civil Rights have been, I can say, terrible. I could even use other words, but I won't. The president's anti-DEI executive order stated DEIA, A is for accessibility programs, policies, mandates, and preferences, were all illegal and discriminatory and all need to be terminated. This included training, hiring, development, and promotion programs, in addition to education programs. Also, positions with DEI responsibilities in the agencies were to be eliminated. The acting assistant secretary for civil rights, in a February 21 released letter called the Dear Colleague letter, interpreted legal standards for Title VI, the Equal Protection Clause of the 14th Amendment, and other relevant authorities to be named. These are to be applied to all recipients of federal financial assistance from ED. This directive followed a ban they had made on all of OCR's investigating, in the process of investigating complaints, in the numbers of 12,000. OCR has approximately 600 nationwide employees in 12 regional offices. This ban applied to all these pending investigations, with the exception of 20 cases that were opened based on presidential priorities. These priorities were getting rid of gender-neutral bathrooms, banning transgender athletes from participating in all women's sports at all levels of education, and alleged anti-Semitism are alleging discrimination against white students. Let that sink in. Following President Trump's executive orders and under the new administration leadership, all federal workers received this email titled Fork in the Road, offering or demanding federal workers to consider taking the offer to resign with pay, which would continue through September 2025. According to a ProPublica article, about 40,000 of all federal workers actually took the buyout by the due date, which was very short, of February 6th. Personnel identified as working on DEI were placed on administrative leave by the new administration and told to prepare for possible dismissal. This included personnel who were required or encouraged by Trump's previous Ed Secretary, Betsy DeVos, to attend diversity training. And now they are being targeted for having attended the training and put on administrative leave because it was pro-DEI. Ed removed or archived hundreds of guidance documents, reports, and training materials that make any mention of DEI-A. Elon Musk's efforts to close Ed is part of dismantling all federal agencies and ending the services and civil rights protections they provide. The Department of Education was created by congressional statute in 1980 and can only be closed by congressional action. In defiance of this, Trump is proposing dismantling Ed by removing each of its functions to other agencies, leaving Ed bare of all responsibilities. This proposal is a component of the president's assertion of total executive authority and power, and dominance over the other branches of government, the congressional and the courts. Presidential acts of defiance have also included ignoring court orders. President Trump asserted his Article 2 constitutional powers over Congress's Article 1 and the court's Article 3 constitutional powers, some say comes close to creating a constitutional crisis. His claims that Article 2's executive authority is superior was enhanced by the recent Supreme Court opinion, giving him thorough immunity for any legal challenges to the president acting within presidential powers. At this time, there are numerous legal cases that are winding their way through the lower courts to the Supreme Court, and presidential immunity remains to be tested by several of these pending court cases. In K-12 education curriculum and books containing race discrimination, history of slavery, and content on LGBTQ+ have been banned. According to an educational group, AA State of Play, curriculum and books whose subject matter includes pro-DEI have been banned by 21 state statutes, with Texas banning the largest number of banned books, followed by Florida and Missouri. Parents have sought to have their children protected from learning the history of discrimination, slavery, Jim Crow laws, and anti-lesbian, gay, bisexual, or transsexual identity. Pushback by ordinary citizens, however, has begun. In a counteractive move, librarians have fought back with lawsuits challenging book banning. The ACLU of Arkansas is representing former Saline County Library Director Patty Hector, who was fired in 2023 by Saline County at Bromley after a campaign objecting to some of the books on the shelves of Saline County. Quote, I could not stay silent as calls for censorship targeted marginalized community and undermined our library's mission, Ms. Hector said and also stated, losing my job was devastating, but I refuse to let these actions go unchallenged. Also, there have been daily increasing numbers of demonstrations throughout the United States. Congressionally held hometown hall meetings have given citizens an opportunity to register their frustration and anger over the results of the acts of the new administrations, and they have registered their opinions. The DOJ In addition, the DOJ prosecutor's letter providing support for current remaining DOJ prosecutors faced with decisions to carry out orders in the Mayor of New York City, Eric Adams case is an example of a supportive letter. It was signed by 900 former and current prosecutors. It is important for all of us to provide encouragement and support to federal employees who are continuing to work under circumstances that remain unclear and hold the possibility of termination always threatening. I thank you. I will answer your questions at the end of all of our 3 presentations.
Thank you, Ms. Esbrook. Ms. Samuels?
I'm Jocelyn Samuels. I am delighted to be here with you, and it's wonderful to see so many old friends and people who are so committed to the rule of law, and in particular to the kind of DEIA initiatives that are so critical to continue to address the systemic inequities that plague our nation's schools, workplaces, housing, and other areas of endeavor. I want to talk a little bit today about DEIA initiatives in employment. It was so valuable to hear from Jeanette about everything that is going on in the education context. But this critical work is also at risk in employment as well. I think that the executive orders and the implementing memos that we have seen over the course of the last month are creating a sustained attack on these DEI initiatives across the board, including in employment. And in my view, the opponents of DEIA work have conflated, either inadvertently or intentionally, lawful and still really important DEIA initiatives with quota hiring. I think the president's executive orders treat DEI as the antithesis of merit, when in fact I suspect that all of us on this call recognize that DEIA initiatives are a way to ensure that entities are considering a broad swath of criteria that demonstrate merit, and that they are non-discriminatory ways to eliminate barriers to equal opportunity that continue to exist as a result of both historic and continuing patterns of barriers and discrimination. I think we probably would all agree that there are legal, business, and moral cases for continuing to pursue diversity, equity, inclusion, and accessibility initiatives. The legal case in employment is that it has long been recognized that practices that disproportionately exclude groups on the basis of demographic criteria, whether it's race or sex or national origin, can violate the law. And so DEIA initiatives help employers to avoid liability for practices that disproportionately exclude people based on protected characteristics. There's also been research that shows that harassment is less likely to occur in more diverse workplaces. And so, for all of those reasons, employers have a legal incentive to engage in DEIA initiatives, not because they are discriminatory, but because they promote a non-discriminatory working environment. There's a business case for these initiatives because research has shown repeatedly that diverse companies are more likely to be profitable, to have improved performance among their employees, to connect more with their customers, to reach a broader pool of applicants, and in general, to benefit their bottom lines. And then finally, I think there's a moral case. DEIA initiatives allow employers to legally work to address persistent and entrenched systemic inequities that often hinge, as I said, on race or sex or national origin. And nothing in the law forces employers to turn a blind eye to injustice. So, what's the status of the law with regard to being able to undertake DEIA initiatives in employment? Well, the first thing to note is that the Supreme Court's decision in the Harvard and UNC cases does not undermine the use of DEIA initiatives in employment. As Jeanette said, the Supreme Court in the SFFA case said that Harvard and UNC's use of race as a criterion in admissions decisions violated Title VI and the Equal Protection Clause of the Constitution. But here's what's different about employment. First of all, Title VI and the Equal Protection Clause are not at issue in most employment cases. Private sector employers are governed by Title VII of the Civil Rights Act of 1964. So the statutes that the Supreme Court was addressing in the SFFA case are different from the main statute that governs private sector employers. Second, what the Supreme Court was addressing in SFFA was university attempts to promote diverse learning environments to improve learning outcomes for their students. I think that is an incredibly important and legitimate goal. And in fact, the Supreme Court acknowledged that diversity could have a lot of beneficial impacts in the classroom, but it is not the basis on which employers have historically done DEIA work in the workforce, because that kind of work has been based on a remedial rationale that employers are acting to address the barriers that continue to limit equality of employment opportunity for people on the basis of race or sex or national origin or disability or age. And so the justification for the kind of work that employers are doing is different from the one that the Supreme Court curtailed in the Harvard and the UNC decisions. Perhaps most importantly, what the Supreme Court was addressing, as I said, was university decisions that considered race as a factor in individualized admissions decisions. That is not what the vast majority of DEIA initiatives entail in the employment context. When I use the term DEIA, I am talking about race-neutral actions that are aimed at creating welcoming, inclusive, and fair workplaces for all, that are designed to identify and address barriers to equal employment opportunity that may be preventing people from realizing Title VII's commitment of equal employment opportunity, and that are taken in ways that benefit everyone in the workplace. Now, I want to be clear. Under Title VII, the main law that governs discrimination in employment, the Supreme Court has made clear that it is lawful for employers to take race or sex into account in individualized employment decisions in limited and carefully designed circumstances where an employer can show what's called a manifest imbalance, which means a significant level of underrepresentation in its workforce or in a job category in its workforce, where it has adopted a thoughtful, intentional, and plan, and where that plan doesn't, and again, this is a quote, unnecessarily trammel the interests of non-targeted parties. So those kinds of plans can still be lawful, and nothing in the Supreme Court's Harvard and UNC decision even mentioned, much less overturned, those Supreme Court cases related to employment. But putting that aside, the vast majority of DEIA initiatives in employment are done on a race-neutral basis, such that they improve the employer's processes and work environment for everyone. They do not take race or sex or national origin into account in individualized decisions. So what are some examples of those kinds of initiatives? Some of them are collecting data about the demographics of an employer's applicant pool or workforce to identify red flags of discrimination. If, for example, an employer tracks the demographics of its workplace and realizes that 80% of its middle managers are women, but only 20% of its senior level managers are women, and they typically promote from within, that is a signal that there is something preventing women from applying for or being selected for upper level positions. It doesn't conclusively prove that the employer is liable for discrimination, but it is a tip-off to the employer that it should do additional investigation to understand why is it that there is such a dramatic drop-off between the representation of women in the middle management ranks and the representation of women in the senior ranks. There is nothing in the SFFA decision that invalidates that kind of proactive employer initiative to identify and address barriers that may exist before they result in discrimination that can be challenged in court. Similarly, looking at retention rates and trying to figure out why it is, if it is, that people in different groups are leaving the workforce at faster levels and rates than others. So among the things that an employer can do under those circumstances are conduct exit interviews to figure out Why are people leaving? Are there signs that they feel unwelcome based on race or disability or some other protected classification? Conducting employee surveys more broadly to get a sense about employee concerns, offering mentoring programs that are available to all employees, or having employee resource groups that help employees who share common interests to come together to talk about their ideas for improving the workplace or their concerns about things that maybe the employer does not realize are creating barriers. As long as those kinds of initiatives are available to everyone, they are DEI work that is perhaps motivated by a desire to address underrepresentation in the workplace, but do not exclude anyone on the basis of race, sex, national origin, or any other protected classification. And as Jeanette said, the Supreme Court has manifested on several occasions that it finds race-neutral measures to be completely acceptable ways to advance equity, even when they are adopted in part to further diversity. So Jeanette mentioned the Boston Parents Coalition case. I'll also note closer to home the Thomas Jefferson High School in Virginia, a very selective magnet school, which did an analysis of its selection criteria and its tests and realized that Black and Hispanic students were significantly underrepresented in its student body, despite their presence in the catchment area, the communities from which the students were drawn. And so the high school decided to change its criteria and to emphasize things like socioeconomic status or the zip code that the students came from. And that enabled them to enroll a student body that looked more like the applicant pool and the demographics of the communities from which the school draws its student body. The school was sued by a coalition of white and Asian parents who said that because these race-neutral mechanisms had resulted in a decline in white and Asian student representation, they were therefore unlawful. And the courts, the district court, the appellate court, and the appellate court said, no, there's no problem with this because the school has simply used race-neutral mechanisms to advance equal opportunity in the school. The Supreme Court declined to overturn the appellate court's ruling in this, which I think is a signal that these race-neutral approaches, whether in education or employment, are things that the court is prepared to acknowledge remain valid approaches to realizing the goals of the equal employment opportunity laws. Now, I just want to address one thing, which is, what is to come. And as Alada said, I was removed from my position as an EEOC commissioner on January 27th, in part based on my support for DEIA initiatives. I do think that everyone on this call should be monitoring what the EEOC does in this context, because once there is a new majority on the EEOC, I do worry that there will be efforts to put out new guidance that will curtail the extent to which employers can permissibly do this work. even though, as I say, I think that the work remains entirely lawful and is critical, and the EEOC may choose to bring lawsuits on behalf of people who feel like they have been harmed by diversity programs, even though an expression of support for diversity does not mean that an employer has taken race into account in a particular employment decision. So I encourage you all to keep an eye on the EEOC website and to monitor what the agency is doing. But I am happy to provide continued input and advice about what I think are lawful and really important initiatives in this space so that together we can continue to make progress toward the goals we all share. So I'll stop now, but look forward to your questions.
Thank you so much, Ms. Samuels. That was great. Ms. Mathis, you're up.
Thank you, Dr. Taylor, and thank you, Sue, for organizing this. It's a pleasure for me to be here today representing the National Council of Negro Women, but also representing about 60 years of my own experience as a Southerner, as an activist, as a Black person, as a woman. On February 21st of this year, United States District Court in Maryland, it's a trial court, issued a nationwide preliminary injunction. Preliminary means just what you think, that it's not final, that there's much litigation to go. But that injunction temporarily halted the enforcement of 3 key provisions of the executive order aimed at DEI programs. There were 3 provisions at play: a termination provision mandating the cancellation of all equity-related federal grants and contracts, a certification provision wanting contractors and grantees to affirm that they are not operating DEI-type programs, and then finally, an enforcement threat provision, which I found most chilling, directing federal agencies to agree to investigate private entities for potential civil rights violations related to DEI. There's so many problems with that last statement. We don't ordinarily investigate potential violations. Our system is designed to investigate actual violations of those for which there's probable cause to believe that they have occurred. The court's ruling, which is preliminary but encouraging, primarily rested on the First Amendment right of free speech, as well as on the due process principle that regulations cannot be unconstitutionally vague and must be clear. There's another concern that is also chilling in the context of executive power, and that is the appearance that this federal judge reached in Maryland, that the concerns about the attempts to deter viewpoints it opposes. If there's anything on which our system is built, it is this notion of free expression, free association, free to believe, whether it's in religion or in politics, free to have your beliefs and have them protected. But this notion of we're going to censor you, not because it is deleterious or illegal, but because you disagree with us. Future rulings may provide additional relief, but I think we can certainly expect that there's going to be more litigation. I see we've only got a couple of minutes, so I'm going to try to race through. Much of what I had planned to say has already been ably said by our other panelists. But what is DEI? There are initiatives that are intended to increase the pool of qualified candidates. And I think it's important that we emphasize no one who favors DEI is positing a theory that those who are not qualified to do the work should be hired or engaged to do it. That is just ahistorical, and it is not true. DEI aims to create a workplace where everyone feels respected and valued. It can remove barriers to opportunities, and indeed, there are barrier studies, statistical inquiries that look and see what are the barriers to equal employment opportunity. How does DEIA benefit organizations? Employee studies show that employees who feel like they belong, that they're in a place that values them, are more likely to be satisfied with their jobs. Glassdoor agency reports that 76% of people who are looking for a job consider a diverse workplace as an asset, not a liability. And it can also be important for talent attraction and reputation. Why do some companies have DEI initiatives in spite of the public comment and the political fray? Mainly because the law is on their side. As Jocelyn has already explained to us, under Title VII of the Civil Rights Act of 1964, employers have an affirmative duty to root out systemic racial discrimination, including identifying policies and practices that create, again, unnecessary barriers. And then Congress strongly encouraged employers in that same act to make voluntary efforts to break down barriers, end occupational segregation, and increase access to opportunity. And this may be the most important question of all. Why is DEI subject to such vociferous opposition? Well, there's the legal risk. There is a risk that if you practice DEI in a publicly traded company, that you might get sued. And from what I'm hearing from our partners who do this work in corporate America, the lawyers are giving very strong advice to keep your head down and don't make too big a fuss about what you're planning to do, because the risk of litigation against you is serious and something that you ought to take into account. Some employees feel that DEI initiatives put them as employees at a competitive disadvantage. Some people believe that women, disabled persons, and people of color are generally not as smart, industrious, capable as white male candidates. Some believe in a winner-take-all economy. Every benefit that goes to a person via DEIA is at the expense of another group. Others believe that women, people of color, people who are gay are incapable of meeting high performance standards and expectations. But there are some companies that are pursuing their DEI programs and activities in spite of the opposition. They include firms like Delta Airlines, Costco, Apple, Elf Beauty, Myers Supermarkets, Procter & Gamble, Sephora, Coca-Cola, and Airbnb. Which companies have abandoned DEI over the past 6 months? Amazon, Pepsi, Target, General Motors, Starbucks, and Toyota. And let me be clear, the organization that I work for, the National Council of Negro Women, has a council of corporate leaders that we meet with on a quarterly basis. We met with them yesterday, and what they said to me and to my fellow coworkers here at NCNW is that they are optimistic and hopeful that they will be able to recast anything that is objectionable or possibly illegal about their DEI efforts in new terms. They talked about things like our ethical code, our moral responsibility, that beyond trying to achieve a certain number or have a certain level of diversity, for many of them, this work is has a moral, ethical aspect to it, wanting to do the right thing for the right reasons. And I want to end up, I think, with this is something that I think about. I assumed that I was an affirmative action baby. I was born in 1954. It was 1966 before I went to an integrated school in South Carolina. When I got ready to go to college, I had pretty fair grades. got a offer to go to Duke University. I assumed that it was because of affirmative action. But what I quickly learned and realized that maybe I did get in on an affirmative action bid, but there weren't any affirmative action diplomas being handed out. There was only one way to earn the degree, and that was through the library in the classroom. So I would encourage people who feel a certain way about DEI to take that into consideration. Why does there seem to be a rising tide of opposition to DEI? Obviously, there are political undertones. There have been successful lawsuits challenging diversity, mostly in the college context or in federal grants. Demographic shifts play a role. People who are of Hispanic or Latino origin or heritage will constitute 30% of the United States population over the next several decades. And that makes some folk anxious. And then I think one that we have overlooked or not paid enough attention to is the decline of the Midwest industrial economic base. I'm talking about coal, automobile manufacturing, and steel. And the middle class jobs that were created by those industries. Created, and it still exists, a huge amount of economic anxiety in what is referred to in a derogatory way, I think, as flyover country. We have not invested in those regions. We have not made sure that children from Appalachia have an opportunity to go to college, no matter what color they are. And I think there's an opportunity there for improvement. And then finally, there is zero-sum mentality. Every job or contract that goes to a person who is not white, able-bodied, straight male results in fewer options for those who are assumed to be superior candidates. I think I will end at that point, and thank you for the opportunity to share my thoughts. Some of them are personal, and I cannot separate my personal experience from what my career as an activist has been. I will say this, that there are what I call 5 smooth stones from the story of David in the Old Testament that can move organizations to embrace the concepts of diversity and inclusion and equity. They are customers. You notice most of the organizations that are continuing their DEI efforts are consumer-facing companies. Board members and executives play a role. Advocacy and civil rights groups we've been involved in as amicus briefs and in other ways with litigation. Some organizations, the NAACP, the Lawyers Committee, the Legal Defense and Education Fund, are all being quite vociferous in pushing back against these cutbacks. And then their employees and their employee resource groups and their unions have influence over the companies that they work for. And finally, probably most important of all, are the shareholders. So we hope that we will survive this period and that we will realize that we are better together. You know, there are some forms of diversity that we don't balk at. When I go see the financial planner, they always want to make sure that my portfolio is diverse. When we do clinical trials to test out new medications, we don't have any problem with diversity, even racial and ethnic diversity in those clinical trials, because we know it results in better medicine and better health care. And then finally, diversity, biodiversity. Where would we be if there was not this vast diversity of animals and plants that support and sustain us and in climates and environments that allow humans to thrive? It's only certain kinds of diversity that give us angst. And perhaps as we move forward, we will learn that those differences are not as important as we might imagine. Thank you for this opportunity, and thank you for bringing the subject before our group.
Thank you, Ms. Mathis, and thank you, Ms. Esbrook and Ms. Samuels. We have a couple of questions given our time, we'll cover. But first, I want to mention, we got a chat message from Nick Newman, who said, I have breaking news, an event unfolding. All SSA, Social Security Administration, EO federal employees across the country just got terminated.
Oh.
And he said, my mom is one of them who's been there for 30 years, working her way up the ladder to a leader position and standing up for all people. He said she's just called crying. So our thoughts and prayers are with your mother and with you and your family members, Nick. We're so sorry for that. We're sorry. But the first question, Ms. Esbrook, Jeanette, this is for you. It says, is OCR even allowed to investigate complaints of discrimination against women, Black and Hispanic students and the students with disabilities? Is it even illegal anymore to discriminate on those bases?
Thank you, Karen Humphrey, for asking that question. Recently, the OCR was allowed to continue investigation on their disability discrimination cases. And of the 1,200 cases that were pending when they received the stop order to investigate, disability cases amounted to 600. So
12,000. Sorry.
okay, my husband said it was 12,000. So was that 6,000 cases?
600, 6,000.
Okay, anyway, the standards that will be used are a little bit up in the air because in that letter from the acting assistant secretary, he stated that these were the changes to Title VI and the 14th Amendment, the Equal Protection Clause of the 14th Amendment, and those were changed. It was the Trump interpretation, and he said there would be other interpretations sent out of other statutes. So the answer is no to women, Black, and Hispanic discrimination, and probably language minorities, but yes to disability. And I do want the opportunity to say how thrilled I am to be on a panel with Janice and Jocelyn. You two provided such wonderful inspiration and information. I know we are all somewhat in a funk about what's happening, and just listening to you and hearing your suggestions and commitment to continue the work no matter what really inspires me. Thank you.
So I have one question that I probably like Ms. Samuels to address or any comments she might have, and then one from Ms. Mathis. So a speaker, she said, Karen, I think it was again, said a speaker interviewed on MSNBC about the attack on DEI said that in light of the cabinet and other appointments in the current administration, DEI really means didn't earn it. Any comments? Or any? You don't have to. I'm just.
Steal that line for subsequent presentations. I think this is an example of the utter upside down Alice in Wonderland aspect of the president's attacks on DEI, that to him and his supporters, DEI by definition means that unqualified women and people of color will be obtaining opportunities at the expense of the only people who really are qualified, which is to say, people who have historically enjoyed all of the advantages that American society has conferred on them. I think the assumption that DEI results in the hiring of unqualified people, as we have said, is completely unfounded. As Janice made clear, there is no argument that DEI is a way to ensure that you hire unqualified people or give unqualified people access to opportunities to which they are not entitled. It is absolutely the opposite. DEI is a way to make sure that you are doing everything you can to ensure that those who are entitled to these opportunities are not precluded from having them as a result of barriers based on their race or their sex or their national origin or some other protected qualification. So I would say DEI is merit-based. It is a way to ensure that
Mhm.
we are offering the opportunities we have to the broadest possible spectrum of people who can take advantage of them without barriers that would otherwise prevent their access.
Thank you very much. Ms. Mathis, there's one that says from Sick Out to you. I'm sending it to you. Any advice on nonprofits using race as one of several criteria on how to grant? I understand the Fearless Fund issue, but can race be one of several factors in granting race, poverty, geography, etc.? Or should race be removed completely as a factor on where to grant to communities?
Let me start on race neutrality by saying that for about 246 years, our country used race-specific measures to defeat equity. And so since about 1965, less than a century, we've now moved into an era of race neutrality, which I'm completely okay with. But I do think that one of the dangers of this not teaching history is that it can give us a false sense of security about who and what we are. I'm not sure that you can cure 246 years of race-specific exclusion with a few decades of race-specific inclusion. Now, what was your question? I got.
It said, any advice on nonprofits
Oh.
using race
Yeah,
as one of several criteria on how to provide grants, I guess?
I think
Should race be removed completely as a factor on where to provide grants to communities, I guess?
there are plenty of indicia. We just got done working on a project in Mississippi about affordable access to broadband connectivity. And even though it was a predominantly Black area that we were working in, I didn't use race to determine where we would focus our efforts. I looked at where are the federally qualified health centers, so that where do people have access to health care? I looked at the number of Title I schools that were in the area that we proposed to address. There are plenty of other indicia that are inclusive, that you don't have to rely solely on race. I personally don't have any problem with race being one of the factors, but there are lots of other alternatives that will get you to approximately the same conclusion.
Okay. Given our time and respect for all the attendees, I'm going to just say, in terms of my closing comments, part of our topic was efforts to maintain and fight back. And so I guess when we look at fighting back, a lot of people are upset right now about what's happening with DEIA, I should say, including the accessibility and what we should be doing. And when people ask me, I just tell them we have to be a part of the solution and do what works best for you. And part of that is, we can volunteer. We can part of political campaigns. We can write our representatives. you know, we can donate, we can run for office, you know, but particularly we can stay in touch with our local legislators to build community online and offline as we're trying to do today. And I guess the bottom line, I just say this is no time any of us can afford to throw up our hands. It's time for us all to roll up our sleeves because these are some very serious times. And that's what I have to say. So I'm going to turn over to our co-presidents, Ms. Klein, Sue Klein, and Jan Erickson for your comments. And thank you all for your participation today. A lot of Taylor signing off. Go ahead, Ms.
Great program. Thank you to everybody. Gosh, and thanks to Jocelyn. It's great seeing you again, Jocelyn. And I personally want to admire you for your courage and determination. Fighting
Absolutely.
back. Boy, that's what we got to do. Also, I want to comment on something Janice Mathis, and thank you for your great career insights. You know, what we're going through in this country is something that's happened in many other countries that have suffered from globalization and having great segments of their population lose the upward economic trajectory that they thought they would be on. So that's part of the larger picture, and hopefully we can talk more about that at some other CWI meeting. But also, Jeanette Lim Esbrook, a lifetime in civil rights activism. Thank you so much for your summary of the law. Really appreciated that. And Dr. Lauder Taylor, you're a wonderful, wonderful moderator and moving things along. So there's just one comment that caught my eye over the week, and it relates somewhat to what I've always thought about at DEI being, which is a generalized empathy for other human beings. It comes from that great philosopher, Jane Fonda. She was speaking at the SAG-AFTRA, the Screen Actors Guild Awards, over the weekends. Maybe somebody saw it. She's so incredible. She said, make no mistake, empathy is not weak or woke. And by the way, woke just means you give a damn about other people. So she also encouraged us to build a big tent, because we're going to need a big tent, bring in lots of people to be effective in pushing back on all of these very harmful initiatives.
Thanks, everyone. Thank you. Have a great rest of the week.